Amazon, SpaceX, and Trader Joe's have recently sued a government organization called the National Labor Relations Board. And before we get into the details of that lawsuit, let me tell you a little bit about what the NLRB is. The National Labor Relations Board is a federal agency that protects workers' rights to conduct activities like form a union and engage in what the National Labor Relations Act engage in what are called concerted activities. So basically a right of employees to work collectively to try to improve their workplace situations. And so it governs unions and also people who were not unionized under Section 7 of the Act. People who are not members of unions are still protected and allowed to engage in what's called concerted activities. So if you want to talk about, let's say, wages at the company or unsafe working conditions or discrimination, then you should be allowed to communicate that, whether it's on social media, through email, with other employees, and not penalized for it. So in this situation, there were, I believe, 9 employees at SpaceX who were fired after they complained about working conditions at one of the plants. And SpaceX then fired them for doing that. First, they interrogated them according to news reports, and then they fired them. They filed a charge with the NLRB. The NLRB opened an investigation, and there was going to be a hearing on this issue. And then SpaceX has now filed a lawsuit, which has been joined by Amazon and now by Trader Joe's, that basically went at the heart of the National Labor Relations Board. And it said that hey, court, forget about these 9 employees and whether or not they were improperly terminated. So SpaceX and these other companies are making a much more fundamental charge against the board, saying that the whole board itself is unconstitutional. And their argument is somewhat technical, but essentially they are arguing that under Article 2 of our U.S. Constitution, that the president has to have the right to remove these judges, right, the NLRB judges that hear these cases, and that the Constitution was violated because in this situation, the judges who hear these cases, according to the lawsuit, can only be removed for cause, and they have to be removed by a higher officer who also can only be removed for cause. So their argument is like, hey, you've got 2 layers of for cause before these judges can even be let go, and therefore it violates Article 2 because the president essentially doesn't, or the administration essentially does not have the power to ensure that laws are faithfully executed, which is what that provision of the Constitution requires. A huge play here, and is part of a larger movement that we see going on by a number of companies and some conservative activists who are trying to attack what they call the administrative state, which includes all the agencies, right, that we hear about in the news, whether it's the National Labor Relations Board, the Securities and Exchange Commission, the Environmental Protection Agency, or the EPA, you name it, whatever federal agency is out there. These agencies that have their own enforcement powers, right, that often have their own judges, they can issue their own regulations, they can issue their own fines. And for decades, many on the right and conservative activists have said that this is governmental overreach. This is the government controlling all aspects of our lives, and there's been a concerted effort to roll they call the administrative state back. And this dates all the way back to the FDR administration during the Great Depression, when the FDR administration created many of these agencies. So since that time, these agencies and their laws have gone fairly unscathed by the judiciary for most parts. We've seen the judiciary and judges in some instances narrow the scope of their enforcement, but nothing this fundamental, where we've got these companies that are taking a shot right at the heart of the National Labor Relations Board. And if they win this lawsuit, then the board wouldn't necessarily be gone, right? But their enforcement action, in this instance, would be completely obviated. They'd be gone. And the NLRB would have to completely restructure itself in order to be constitutional. So we'll see what the court does. This is also part of a case, well, not part of a case, but part of the same movement that brought a case before the court challenging what's called the Chevron Rule. And the Chevron Rule is now probably 50 years old, which basically says that in courts in reviewing an agency decision, so let's say the NLRB comes out with a new regulation or enforcement, that if challenged, a court in reviewing those regulations or reviewing those actions has to give deference, right? It has to give deference to the agency. Essentially, it can't overturn the law or the decision unless it's clearly outside of the bounds of the law, because the court should defer to the agency, because the idea is that the agencies have the expertise. That is fundamental to the administrative state, is that you've got experts that are interpreting congressional laws, which are often very vague and conclusory, because when they pass laws, they're often, they can't cover every situation. And so you have administrative agencies with expertise. So let's say it's, the Nuclear Regulatory Commission or the Environmental Protection Agency. You've got scientists and engineers and people who know the technical aspects of these laws and these regulations. And so the argument goes, the court should then defer to those experts, because the courts aren't experts in these areas, the agencies are. That doesn't mean courts can't ever overturn them. They can, but again, the overreach or the argued overreach by the agency has to be so broad that it's clearly outside of the bounds of the law for the court to overrule it. Now there's a case that's already been argued, we're waiting for the decision to come down, where some of these groups have challenged it and said that Chevron deference should no longer apply. The court should essentially have, on equal footing with the agency to be able to overturn, an agency's actions or decisions. So this is part of that same narrative. The Chevron case is going to be huge. Again, it's been argued. We're waiting to see what the court's opinion is on it, and which I think will affect this sort of action, where they're taking a shot right at the National Labor Relations Board. So we shall see, what happens in this case. So what does it mean for employees? Well, it means a lot. First of all, the NLRB, if you are trying to unionize an employer, or if you've already got a union and there's a dispute about, something about how the company is treating the union, the National Labor Relations Board, under the National Labor Relations Act, is the agency that hears these complaints and essentially, is the referee calling balls and strikes on how companies and unions can interact with each other. And then for those of us who are not in unions, as I mentioned earlier, the NLRB has enforcement power to ensure that employees can engage in collective action. So you can complain about workplace conditions, you complain about discrimination, you can raise issues about, let's say, equal pay, and not fear reprisal or not fear dismissal. Though obviously you can be dismissed, because that's what happened in SpaceX, but then you have a claim that your rights under the National Labor Relations Act have been violated. So if the National Labor Relations Board goes away, if they are successful in killing it, at least the current iteration, then these protections are up in the air, and they impact all of us in almost every workplace. So this is a significant issue. It is definitely one to watch.